Our next speaker is Professor Maurice Cullity, QC. Professor Cullity was educated at the University of Western Australia and at Oxford. He taught estate planning and related subjects at the University of Oxford, Western Australia, Melbourne, Pennsylvania, and since 1968 at Osgoode Hall Law School. Professor Cullity was called to the bar of Middle Temple in England, the Supreme Court of Victoria in Australia, and Osgoode Hall. Ladies and gentlemen, Professor Cullity.
Ladies and gentlemen, as your program tells you, my subject is the exercise of discretionary powers by trustees, and I presume I'm expected to put the emphasis on recent developments. And at the outset, I feel obliged to say that I don't find, and I haven't found this, to be a particularly easy topic. But I think you'll agree that it's often quite difficult to advise trustees with respect to the scope of particular discretions and whether they can be exercised in particular circumstances. And so perhaps it's not all that surprising that it's difficult to make useful general statements about the exercise of discretionary powers. And yet I don't think I need go to any lengths to try to demonstrate that the subject has some practical importance. Over the last few years, a number of you will have wrestled with the problem of distributions from companies, distributions of tax-paid undistributed surplus that have been received by trustees or by executors of estates. At the present time, some of you may be concerned with the ability of trustees to make encroachments and thereby incidentally and coincidentally affecting the succession duty payable with respect to somebody who died before April of last year. And quite apart from these somewhat special cases where the problems have arisen because of changes and developments in taxation law, the fact that trustees continue to have problems with their discretions is, I think, amply demonstrated by the comparatively large number of recent Canadian cases in which the conduct of trustees has been called into question. And I think in most cases, in the reported cases anyway, successfully called in question. And among the more recent cases on discretionary powers, we have a number concerning powers and duties of sale. And Madam Justice Wilson has referred already to some of these, but there's the Fales-Wolleben case in the Supreme Court of Canada, there's Wright in the Supreme Court of Ontario, Smith in the Court of Appeal of Ontario, Lauer and Steckel in the Supreme Court of Canada, and the as yet unreported decision of the Supreme Court of Canada reversing the decision of the Ontario Court of Appeal in Lotman. And we've also had a number of really very interesting decisions on the even hand rule with respect to powers of many different kinds. Smith, of course, involved the even hand rule and its application to powers of sale. Fleming in the Supreme Court of Ontario again concerned the even hand rule and its application to powers to control a corporation. Zive out in Nova Scotia concerned the application of the even hand rule with respect to powers given to a trustee under the Income Tax Act. And that, I think, is a very important and a very interesting decision. I'll say something about it later. And then we've had two relatively recent decisions in Ontario on powers of encroachment. One of these, powers to encroach on capital for an income beneficiary. One of these decisions, Blow, was reported in 1978. The second one, Hinton, the decision at first instance has just been reported in 1980 Estates and Trust Reports, but I understand that that decision has been upheld on appeal to the Court of Appeal, and of course the Court of Appeal's judgment is not yet available, if there's going to be a judgment. Now, all those cases, or those particular cases, are concerned with the even hand rule and its effect on powers of encroachment. And then finally, in Blow, which I've already mentioned, Mr. Justice Rutherford provided us with an extensive consideration of the limits to the court's supervisory jurisdiction over trustees' discretions. And he considered also the situations in which trustees are entitled to look at memoranda stating the wishes of the testator. Well, my assignment, as I understand it, is to attempt to identify in a general manner some of the practical implications of these recent decisions for trustees, for their professional advisors, and for people who are concerned, professionals who are concerned in drafting wills. And I want to begin, like an academic, by saying something about the concept of discretionary powers and the significance of inserting a statement in a will or a trust instrument that a particular power is to be exercisable according to the discretion of the trustee, exercisable in his discretion or as he sees fit. And I presume it's reasonably clear that when we put words like that into a clause which confers a power, we're attempting to say the decision is to be that of the trustee and not that of the court or of anyone else. And also, I think we're saying the considerations which the trustee is to take into account in exercising his power are for him, are for the trustee to determine. It's up to the trustee to decide what are the relevant considerations. And if we're saying that, we're obviously trying to weaken or exclude the equitable standards that Madam Justice Wilson mentioned, the even hand rule and the prudent man rule. And I think it's important to ask, to what extent does the law of Ontario allow us to do that sort of thing at the present time? And I'm not going to inflict a long historical discussion on you, but I think it's possible to make out a case for the proposition that there's been a considerable ebb and flow in the attitude of English courts here, and to some extent, perhaps to a lesser extent, in the attitude of courts in Ontario. And I think that you can make out a case along these lines. In the early 19th century and in the 18th century, when lawyers drafted wills and imposed administrative powers, they normally said simply, "It shall be lawful for my trustee to sell, to retain," or "I empower my trustee to sell or retain." And it was there was no question at all that in exercising powers drafted like that, the trustee was compelled to observe the even hand rule and the prudent man rule. And I think in an attempt to weaken the supervision exercised by the courts, the practice grew up of adding words such as "if he sees fit," or "if in his discretion he sees fit." And there are some early 19th century cases where the court said, well, these words make a difference. But then as it became a standard part of practice, everybody conferred powers in those terms, you can see the courts, the English courts, drawing back and starting to exercise their supervision again. And by the 1870s, the English courts were practically ignoring the element of discretion in certain powers. A power to apply income for the maintenance of a family in such proportions as the trustee should think fit, the English judge would simply take that discretion over himself and tell the trustee how to exercise it. And as an inevitable reaction, lawyers started adding additional words. And it became common to say that my trustee can do such and such, not if he sees fit, but if in his absolute and uncontrollable and in some cases irresponsible, they said, discretion, he thinks fit. And the really surprising thing is that the first case in which these discretions, the first appellate case in which discretions described in this way appear to have been considered was the House of Lords decision in Gisborne and Gisborne. And Gisborne and Gisborne for years has been the last resort of the trustee who's really in trouble. Because the House of Lords in Gisborne and Gisborne said that if you confer a dispositive discretion, that is a discretion to distribute income, to apply income for maintenance, and I presume a discretion to deal with capital also, at least in those cases, if you describe the discretion as absolute and uncontrolled, the court cannot interfere unless the trustee has been guilty of mala fides. And that were the words of Lord Cairns in the House of Lords were extremely emphatic, and it's perfectly clear that his contemporaries, English judges, didn't understand him to be saying or to be using the word mala fides in a very broad sense. Because for the next 20 years, remember I said I wasn't going to give you a long discourse on history. I'll try to get off this as quickly as I can. But for the next 20 years, there are a number of reported English decisions in which judges said, well, if the discretion's uncontrollable and there's no mala fides, we can't interfere. And mala fides seems to have been understood as referring to bad faith. And last year I spent my sabbatical leave with the firm of Davies, Ward and Beck, and it's very fitting that the first case I'm going to refer you to is a case called Davy against Ward. Howard Beck, I presume, was still at school. But in the year after Gisborne and Gisborne was decided by the House of Lords, two cases came before Vice-Chancellor Maylands. The first one was Davy and Ward, and the other was Tabor and Brooks. And each of these cases involved powers to distribute income for the maintenance of a beneficiary. In Davy and Ward, a class of beneficiaries. In Davy and Ward, the power was to apply the whole or such part of the income as the trustee shall see fit for the maintenance of the family. Vice-Chancellor Maylands disagreed with the way in which the trustees were exercising the power. He didn't say that it was particularly unreasonable or anything like that. He simply assumed, as the courts had done before Gisborne and Gisborne, that he had control over that kind of power, and if he disagreed, he could tell the trustee how to exercise it. He said it would have been quite different if the discretion had been described as absolute and uncontrollable. Well then, in the same year, he was faced with the facts of Tabor against Brooks, where the testator had given to his trustees an uncontrollable and irresponsible discretion to distribute, which I think you might say they had exercised in an irresponsible way, to distribute income for the maintenance of Mr. Tabor and his wife and his issue. And the trustees distributed all of the income to Mr. Tabor, and when his wife applied for a distribution for herself and the children, the trustees refused to do so. The report tells us that Mr. Tabor had for the last 5 years been addicted to very intemperate habits and was frequently intoxicated and violent in conduct to his wife, so that it was impossible for her to live with him. We're told that the wife had absolutely no means of support at all. The children were destitute. She applied to the trustees for an exercise of their power to give her maintenance. The trustees said no. Vice-Chancellor Maylands said it was settled by the decision of the House of Lords in Gisborne and Gisborne that he couldn't interfere in the absence of mala fides, and he said Davy and Ward was totally different because here he was dealing with a case of an uncontrolled discretion. Now, the result seems quite remarkable, quite extraordinary. The very proposition that by adding a word such as uncontrollable or sole, an enormous effect is had on the jurisdiction of the court also seems extraordinary. But just as extraordinary, if you look at the English treatises today, most of them still draw the distinction. They say the power that the court has over an absolute and uncontrollable discretion is much less than it has over other discretionary powers. And as recently as 1970 in the House of Lords in Regal Benkian settlement, Lord Hodgson said that if the discretion was expressed to be uncontrollable, the court could not interfere unless bad faith was shown. In the following year, in 1971, Lord Reid in Re Baden's trust deed made similar statements. And there are many other statements, particularly in the years immediately following Gisborne and Gisborne. Well, the question is, whatever the position is in England, what's the position in Ontario? And obviously it's unlikely that a judge here is going to say Gisborne and Gisborne is bad law. It's a decision of the House of Lords. There have been cases in which it has been followed expressly by judges in this jurisdiction, but I still think that there is no doubt at all that a lawyer who advises a trustee that the presence of the word uncontrollable or absolute has a significant effect on the supervisory jurisdiction of the court is probably giving very dangerous advice. And I think the point is, quite apart from anything else, there are too many ways in which a court can justify a decision to interfere without running counter to the principle in Gisborne and Gisborne. The techniques are familiar. The first one, of course, is to construe the instrument so that the discretion is not attached to the particular act that the trustee wishes to do. That is sometimes useful. It's not the most common or the most important method. You simply say that the judge simply says the discretion applies to the decision whether to sell. It doesn't apply to the manner in which the sale is to be conducted or something like that. A more important technique is for the judge to say, well, if you stay within the limits of your discretion, then clearly we can't interfere unless you're guilty of mala fides. But if you go outside the scope of your discretion, then of course that's a different matter. And in determining whether you're inside or outside the scope of your discretion, the judge is entitled, and we have recent authority for this, to look at the purpose for which the discretion is conferred. And very rarely, sometimes it happens, but very rarely has the testator told you what the purpose is. Once the court refers to purpose, that means that the distinction between relevant and irrelevant considerations comes in. And once you have that distinction, it's very easy for a judge who disagrees strongly with a decision by the trustee to say they must have considered irrelevant considerations. And very shortly after the decision in Gisborne and Gisborne, Mr. Justice Middleton in the Supreme Court of Ontario distinguished it precisely on that ground. The facts were very similar to Gisborne and Gisborne. He said, but if the trustee exercises the discretion for a purpose other than that which the testator had in mind, then Gisborne and Gisborne is irrelevant. A third technique, which has been used quite recently by Mr. Justice Rutherford in re Blow, is to say, but the trustee has a duty to consider the exercise of his discretions, and that is quite independent of Gisborne and Gisborne. If he takes irrelevant considerations into account, he has not considered his discretion. He has not exercised his discretion in that sense, and the court can interfere. And that's what was done in re Blow. In re Blow, the trustee, the corporate trustee, had looked at a memorandum prepared and executed by the testator, which set out his thoughts about the way in which the discretion might be exercised. Mr. Justice Rutherford decided, for reasons that I'll mention later, that the contents of that memorandum were irrelevant. He said, as the trustee has regarded itself as bound by the memorandum, it hasn't really exercised its discretion. Gisborne and Gisborne is irrelevant. I can interfere. The court can interfere. And the final technique, which has been used in some cases, is to face Gisborne and Gisborne squarely and to say, but the court can interfere in cases of mala fides. What does mala fides mean? It encompasses anything which would conflict with the prudent man rule or the even hand rule. And we've got statements in some cases that a want of ordinary prudence amounts to mala fides in this context. And in re Blow, Mr. Justice Rutherford made it perfectly clear that, in his opinion, the addition of what have been called the amplifying adjectives, like uncontrollable and absolute, have no effect on the supervisory jurisdiction of the court. Well, now, if it follows from that, and I think it's a reasonable proposition, that a draftsman does not weaken or exclude the normal standards applied by equity to a trustee's powers to any significant extent by using words such as he sees fit or in his absolute and uncontrollable discretion. I'm not saying these things may not help in certain cases. What I'm saying is that I think it's unwise to place great reliance on them when you're advising a trustee. Well, the question then arises, is there any way in which the draftsman can weaken the normal standards imposed by equity, the prudent man standard and the even hand rule? And I don't think there's any doubt that it can be done. There are certain techniques which draftsmen have used in the past which have not succeeded. One of them is the sweeping exculpatory clause, which says, I exonerate my trustee from any loss caused by his omission or negligence. The courts normally say to that, and there are House of Lords decisions to this effect, those clauses don't protect the trustee if he has been grossly negligent, and in this case, the trustee was grossly negligent. Another technique is to say, my trustee has power to interpret the words of the instrument or to settle any disputes in his complete discretion. Again, the courts have never given much effect to provisions like that. I've seen one clause which was used in Ontario, in fact was put forward as a precedent by a lawyer in Ontario, which said, in effect, in exercising any powers under this trust, I absolve my trustee from paying any attention to the even hand rule. I have some doubt whether, again, that particular type of provision would have any effect. I think the problem here is that you've got a notion of repugnancy. The courts are saying the trustee is a fiduciary. Anything in the will that says he is to be uncontrolled is inconsistent with that, and we'll ignore it. Well, how can you weaken the standards? You can do it, obviously, by being very specific. Not by being general, by being specific. Normally, an unrestricted investment power won't give a trustee, the courts won't regard that as giving a trustee power to invest on just personal security. There are cases to that effect anyway in the United Kingdom. But clearly, if you're specific in the instrument, you can say, I authorize my trustee to invest on purely personal security, if you're specific. The even hand rule can, I'm quite sure, and we've got a recent unreported decision of the Court of Appeal on this that I'll mention in a moment, you can exclude the even hand rule, again, if you're specific. You can say, in exercising this power to encroach on capital, I direct my trustees to give main priority to the interests of the income beneficiary. And if I just refer you to the clause that was actually used in Re Hinton, this again is reported recently in the latest issue of the Estates and Trust Reports, and the decision, I understand, has been upheld recently in the Court of Appeal. The particular power to encroach on capital in that case ended with the words, it is my intention, therefore, that any doubt as to the desirability of a given encroachment on the principle of this trust fund for any of the aforementioned purposes be resolved in favour of making such encroachment. And my trustees are hereby authorised to make such encroachment without regard to the usual rules of trust administration requiring impartiality between life tenant and remainderman, and without regard to the degree to which the principle of the trust fund is hereby depleted. So the trustee was told that if it had any doubt about whether or not to exercise the power of encroachment, it was to exercise it, and the even hand rule was not to apply, and I presume that is a clear indication that the interests of the income beneficiary could be preferred. Mr. Justice Griffiths, at first instance, appears to have accepted the validity. He placed some reliance on that provision. I don't know what happened in the Court of Appeal, but that would seem to be an indication of a way in which you could, by being specific, weaken the even hand rule. Well, now, if you do that, of course, you exclude the equitable standard at a price. The more specific you are, the least or the less useful your power is going to be if unforeseen circumstances arise. And of course, one of the reasons for putting discretions in a trust instrument is to allow the trustee to handle unforeseen, unpredictable circumstances. You might, in drafting your power of encroachment, be very specific and say it's to be used for maintenance in cases of illness, emergency, and then the Government of Ontario, the Parliament of Ontario, abolishes succession duty, and you find your power is much too narrow to allow you to do what you'd like to do in the particular circumstances. But where, and I think there will be many cases where this can be done, where it can be done, I see no reason why lawyers should not attempt to direct the trustee to give preference to the interests of particular beneficiaries. And I think the trustee is going to be in a much stronger position if he's under attack in a case like that than if he is merely given the widest and most uncontrollable and irresponsible discretion under the terms of the instrument. I think on the whole that should be done in the instrument itself. But that really leads me on to another aspect of re blow, the question of the trustee's ability to look at the memorandum executed by the testator mentioning the circumstances in which he would like the discretion to be exercised. Now, Mr. Justice Rutherford did not give great effect, and that's an understatement, to the memorandum left by the particular testator. The memorandum was executed as a will. It was signed at the end and witnessed, and it was addressed to the trustees, and it was executed contemporaneously, I believe, with the will. Mr. Justice Rutherford said it was irrelevant, it was merely precatory, it should not be admitted to probate, and that the trustee had failed to exercise its discretion by regarding itself as bound by the contents of the memorandum. But I think it's important to note that His Lordship did not say that the trustee had committed any impropriety in referring to the memorandum. That may seem to be cold comfort, but it may have some implications. He said, "I do not doubt the propriety of Canada Permanent's considering the memorandum's provisions in making a decision, but it should be recalled that the memorandum by its terms was intended as a guide only." And the ground of his decision seems to have been that the trustee, the corporate trustee, had regarded itself as bound by the terms of the memorandum. And if that's so, then I presume that, and it has, I understand, been a fairly common, or not an uncommon practice in Ontario for testators to draft little instructions to their trustees and to enclose them with the will. It looks as though it's safer to have the thing executed as a will, but of course now that we have holograph wills, there's no, I suppose, no great difficulty in that. I would suggest it's still safer to have it, your direction to your trustee, your instructions or your guide to your trustees, either inserted in the will or at least incorporated by reference. I think that is, on the whole, a safer way of dealing with it. Now, a further aspect of reblow, and there are many points considered in this case, but a further one that I think is of some importance is that, and I might say at this point that my information about the facts of this case comes entirely from the report, and I haven't been talking to anyone about it. But the officer, the trust officer or the executive of the corporate trustee, Canada Permanent, chose to remain silent when cross-examined on his affidavit. He claimed privilege with respect to the reasons that the trustee had the reasons for the trustee's decision not to exercise their power to encroach on capital. He said, "I do not have to reveal the reasons of the trustee." Now, that's interesting. There's been authority, and quite respectable authority for many years, that a trustee does not have to give reasons to the beneficiary with respect to the exercise of his discretions. I'm not aware of any case which has extended this privilege to the situation where litigation has commenced and the trustee or his agent, his officer, is being cross-examined on his affidavit. Mr. Justice Rutherford did not utter a word of criticism, express or implied, as far as I can see, of the fact that the trust officer remained silent. But what he said was, in view of the fact that the trust officer has remained silent, I will have to try to determine the reasons of the trustee from other evidence, such other evidence as there is. And he ultimately came to the conclusion that the trustee's reasons were irrelevant, and therefore the trustee had not considered its discretion. And I wonder whether, whatever the legal position, whether there won't be cases, assuming that the trustee has had reasons for his decision, there won't be cases where, at least when you get to litigation, the prudent thing would be to give reasons and to give careful reasons rather than to rely on the particular privilege. All right, now, I said also at the beginning that we've had a number of interesting decisions on the even hand rule. And I mentioned those decisions, and I want to say something about them. But I think perhaps I could preface my comments by saying that there is, I think, a quite considerable difference between the law of Ontario and the law of other Commonwealth jurisdictions, or at least non-Canadian jurisdictions, with respect to the even hand rule. Yesterday, when I was desperately trying to think of something to say, and eventually, having read the new decisions, I uttered a little prayer of thanks to the Canada Permanent Trust Company, who seems to have provided so much material for my comments. Yesterday, I had a look at 4 or 5 English treatises on trusts. I looked at Hanbury's Modern Equity, Snell's Principles of Equity, Nathan and Marshall on trust, Halsbury on trust, Underhill on trusts. And I tried to find references to the even hand rule. And then you find them eventually under various headings. But in every case, almost the entire discussion of the even hand rule is nothing more than a discussion of the rule in Howe against Lord Dartmouth. You do not find in the English treatises enormous significance given to the even hand rule. And we, of course, have had it applied in the cases I've mentioned in very, very diverse contexts. And I think that's quite interesting because I think it's another area in which the law of Ontario may have diverged from the law of England. In particular, you don't find in the English treatises any indication that the even hand rule by itself could impose a duty on trustees to sell assets in the trust. I've found no indication of that in an English textbook. And if you look at the classic article on Howe and Lord Dartmouth, the classic English article in the Conveyancer and Property Lawyer of 1943, an article by S.J. Bailey, you'll see that Professor Bailey begins with statements which sound a little strange to those of us who've had any contact with practice in Ontario. He says, "It is axiomatic that a trustee who is holding property on trust for A for life with remainder to B is under no obligation to sell that property even though it is producing no income or even though it is producing a lot of income but is hazardous or wasting." He said it's perfectly clear that's the general rule. He says in a footnote the even hand rule does not impose this obligation. He said the only exception is where Howe and Lord Dartmouth applies. And I think that's the traditional English position. Now, after the decision of in Rees-Smith that Madam Justice Wilson referred to, it seemed quite clear to me that if that was the English position, it wasn't the law of Ontario, because in that case, Mr. Justice Keith, and my understanding is the Court of Appeal agreed with him, in that case, Mr. Justice Keith said, it is inescapable that the trustee is in breach of his duty to maintain the investment. Inescapable that the trustee is in breach of his duty to maintain the investment because the trustee did not sell it and reinvest the proceeds in securities which would produce a higher rate of return. Remember, in Rees-Smith, the trustees were holding Imperial oil stock. The return was 2.5%. The income beneficiary said, I can't possibly make ends meet on $27,000 a year. And Mr. Justice Keith and the Court of Appeal, as I understand it, said the even hand rule imposed a duty on the trustee to sell to hold the balance evenly between the life tenant and remainder man. 2.5% is too small a yield. Well, I thought that the way the law of Ontario was moving was that soon we'd be able to say, forget about Howe and Lord Dartmouth. Because once you have a general principle that to hold the scales evenly, the trustee must sell if the property is unproductive, then you don't need Howe and Lord Dartmouth. It's simply an illustration. But my understanding is that the Supreme Court of Canada, in an unreported decision as yet delivered on January the 29th of this year in Re Lotman, have reversed the decision of the Ontario Court of Appeal and held that if unproductive or underproductive real estate is settled in a trust or is contained in a residuary gift in a will to persons on succession, the trustees are under no obligation to sell that real property. You leave the residue of your estate to your beloved wife for life with remainder to the children. The residue consists almost entirely of real property. The trustee and the real property is unproductive. Although you've directed the trustees to pay the income from the real property to your spouse, as a general rule, there is no obligation on the trustees to sell that property, and because Howe and Lord Dartmouth traditionally has not been applied to real estate. As I read the judgment of the Supreme Court of Canada, what is being said is, in 1802, Lord Eldon said there was no duty to convert real estate. The historical basis for that part of Lord Eldon's decision disappeared in 1837, but lawyers in Ontario may not have noticed this yet. and they may have been drafting wills assuming that Howe and Lord Dartmouth doesn't apply to real estate, and therefore Howe and Lord Dartmouth still doesn't apply to real estate in Ontario. The Court of Appeal had said the historical basis for exempting real estate never really applied to Ontario. Real property in England is most commonly productive. Here it's often unproductive. It's never had the sacrosanct status that it had in English courts at the turn of the 19th century. Though that decision, as I've said, was overturned on the ground that you people have been drafting wills for generations, keeping in the back of your minds all the time that Howe and Lord Dartmouth doesn't apply to real property, and I congratulate you for it. Okay. It seems to me there's a contradiction between saying, as I believe the Court of Appeal said in Rees-Smith, that the even-hand rule itself can impose a duty to sell if the property is underproductive or hazardous, and saying that Howe and Lord Dartmouth doesn't apply to real estate, because it seems to me you either accept the general principle of the even-hand rule and forget about Howe and Lord Dartmouth, or you accept Howe and Lord Dartmouth and conclude that in no other case does the even-hand rule impose a duty to sell. Now, my time is disappearing rapidly. I just mentioned one or two other cases on the even-hand rule, and I was keeping until last the succession duty problem with powers of encroachment, because it wasn't sure to me whether this was a peculiarly appropriate time to talk about it or a peculiarly inappropriate time to talk about it. I knew it was one or the other, but it looks as though I won't have time to talk about it, so that problem will be solved. But I mentioned two other cases on the even-hand rule, Re-Zive and Re-Fleming. Re-Zive was the decision of Mr. Justice Hart in the Supreme Court of Nova Scotia, in which he held that the statutory power conferred upon a trustee to flow through or to pass through a deduction for capital cost allowance under Section 104, subsection 16 of the Income Tax Act is subject to the even-hand rule. And in that case, where you had property held on trust for A for life, remainder to B, and the trustee was holding depreciable property and had given the deduction for capital cost allowance to the income beneficiary, Mr. Justice Hart held that this was improper because the income beneficiary would get the deduction from income. There was a possibility of recapture of capital cost allowance down the line, and that possibility would increase the tax burden on the remainderman. So he said in that situation it was improper for the trustee to pass through the ability to take a deduction for capital cost allowance, and again the decision is put firmly on the even-hand rule. And in that case the even-hand rule clearly was used to preserve the status quo, preserve the balance. Similarly in Re-Fleming, in which Mr. Justice Osler advised the trustee that by exercising its control over itself or themselves as directors, the company should redeem preference shares rather than distribute a cash dividend. He did it on the basis that the cash dividend would deplete the value of the shares and benefit the life tenant at the expense of the remainderman. By using the money to redeem preference shares, the balance would be preserved. But there are cases in which it was possible to maintain the balance and still exercise the power. The more difficult cases are cases where you have powers to encroach on capital for an income beneficiary, and any exercise of the power is going to disturb the balance. And that, of course, is the problem that we have in the context of succession duty at the moment. The problem here, of course, is simply that if the testator died before the particular date in April of last year, leaving his property to his spouse for life with remainder to his children, and the trustees can lawfully encroach on capital to the spouse, even now, it looks as though there's no question that succession duty on the capital interests, on the remainder interests, is avoided. But of course, the exercise of the power has to be lawful. And that means you've got to read the power, and if it's confined to the maintenance of the spouse, you might be in some difficulty. If it's drafted in wide terms for the benefit of my spouse, for example, and there's no reference to maintenance or illness, we have authorities that say that benefit is the widest word of all, and that it includes any material improvement in the, any improvement in the material situation of the beneficiary. On the other hand, and I think this is important, remember we have also cases which say the trustee has to satisfy himself that the encroachment is to be used for the benefit of the beneficiary. He must know why the beneficiary wants the money, he must consider that reason and satisfy himself that it will be beneficial to the beneficiary. And without saying anything more on this somewhat contentious subject, it's clear that in some cases, by conferring a benefit on the children, you are not, in other words, by saving succession duty on the children, you are not necessarily conferring a benefit on the person for whose benefit the power was given, the life tenant. And the problem is a difficult one, and I won't say anything more about it. Let me simply conclude with a reference to the decision in Fales-Woolabin that Madam Justice Wilson mentioned, and the decision in Rewrite. And as Madam Justice Wilson said, these cases have been discussed at length by Donovan Waters in the Canadian Bar Review and the Estates and Trust Quarterly, and I don't really feel there's any point in saying much more about them, except this as far as Fales is concerned. It's one of the very, very few cases in the British Commonwealth in which a trustee has been found liable for not exercising a power to sell. One of the very few cases in which a trustee has been found liable for not selling property which subsequently depreciated in value. I know of no English cases to that effect. And that may reflect the different attitude of English courts towards the supervisory jurisdiction over discretions. Secondly, Mr. Justice Dixon in the Supreme Court of Canada said the standard of care imposed upon a trust company is no higher than the standard of care imposed upon a lay trustee, such as the widow in this case. But the standard applied in that case was very clearly a high standard, and of course the trust company was held to have fallen, to be in breach of it. And thirdly, notice again that Mr. Justice Dixon said that Section 35 of the Trustee Act, which allows the court to excuse a trustee, can clearly be exercised in favour of a trust company. It's not true to say that the court can't relieve a trust company under that section. But then, as in every other case that I'm aware of, the court said, but in this case we don't choose to do so. And finally, and this is one of the more important aspects of the decision, Mr. Justice Dixon said that the professional trustee had a duty to keep the lay trustee fully informed and a duty to try to persuade the lay trustee to reach the decision that the professional trustee thought was advisable. If the corporate trustee was unable to persuade the lay trustee, Mr. Justice Dixon said quite clearly the professional trustee can always go to court and ask the judge to solve the problem. And there, of course, is the trustee's dilemma, which was exemplified so clearly in Rewrite that followed. It is traditional for the courts of Ontario to say, it's not for us to tell you how to exercise your discretion. There are cases in which trust companies have been very strongly criticised in this province for going to court. And one might ask, what is the point of telling the trustee to go to court if the court is not going to answer? It appears that the only purpose served is that the trustee demonstrates good faith and diligence. And it seems a very expensive way to force the trustee to do that. And I wouldn't have said this except Madam Justice Wilson, who of course has the advantage that she speaks with authority, but she did use the word unsatisfactory. It does seem to me that there's something unsatisfactory here, that the courts are prepared to say where you didn't exercise your discretion properly, you could have gone to court, and at the same time they say if you go to court, you've got to exercise your discretion, it's not for us to tell you what to do. I don't want to exaggerate the point because, as Madam Justice Wilson said, when Canada Permanent, having been found liable for a loss in the Fales case, immediately went to court in Rewrite, Mr. Justice Craig said, you don't even have a duty to sell. You've been misreading the trust instrument. There's a power to sell, but not a duty. That, I think, must have been very gratifying to the trustee, particularly as the clause seems, and there's obviously a misprint in the law reports, it seems to have been identical to the clause in Fales and the identical identical to the clause in Royal Trust and Crawford. And perhaps that underlines really the only theme I can get out of these recent cases, and that is, however widely a trustee's discretionary powers may be drafted, the discretionary power of the court is always going to be considerably wider. Thank you very much.